The next case is Italian American Defense League v. City of New Haven.
Good afternoon, everyone. My name is Norm Pattis. I represent the Italian American Defense League and Mr. Mark Borelli. The issue in this case is quite simple, and that is whether standing was adequately pled.
Can I just ask if you could raise the podium a little bit?
Yes.
A little difficulty hearing you.
I'll scooch down and do this.
I
apologize.
Really close. That's good.
The issues in this case revolve around the question of standing, whether it was adequately pled, and if not, whether the district court erred in dismissing with prejudice. We say there was standing, and we rely in part on some very evocative language from Summers versus Earth Island Institute, where it talked about the need for harm in fact. And in Summers versus Earth Island, there was a sort of, and it says, if the harm in fact affects recreational or even aesthetic interests of the public, that will suffice. And in this instance, we pled, or what was pled, was that a person's interest in his home and in his neighborhood was affected.
So I get that point. So if it confers standing, if I want to go visit the wildlife at some place abroad, and interference with the wildlife is an injury that confers standing, it's got to be the case that if you alter the environment in which I live, if I have allegations that I decided to live there because of the environment, it's got to be that there could be an aesthetic injury, right? That's your point.
And does
it matter that Mr. Marcarelli has moved to Florida if the relief you're seeking is restoration of a statue in New Haven?
Yes, it does. Why did he leave the neighborhood? If he left the neighborhood in part because of this alteration and sold his home at a discount rate because he figured...
So he'd come back if they restored the statue?
No, but he might seek damages for the loss of the value of his home and the loss of satisfaction he had in living there. The contention is, and this is not a mere evanescence...
And you're seeking damages in addition to the injunctive relief?
Well, as to Mayor Elliker, yes.
As to what?
As to Mayor Elliker, the second defendant in this instance, because what happened...
Well, you need standing for each.
I'm sorry?
Because you need standing for each claim for relief, right? So just about the injunctive relief, if he doesn't live there anymore, he probably can't seek an injunction to restore a statue.
No, but if he's similarly situated to the IADL members...
Right, so you're saying there are at least some members of your organization who do live there.
That's correct.
And care about the character of the neighborhood.
That's correct, and it's not a transient interest. I'm tempted to be glib and say beauty is in the eye of the beholder, but that would sell short all the aestheticians in the audience in that branch of philosophy. But these are historic interests that have been recognized in New Haven for a long time. That statute was a gift incident to the lynching of Italian Americans in New Orleans 125 years ago. The city accepted it. It's recognized and regulated by the Historic Commission.
So I get that point, and maybe my colleagues will have more questions about standing, but the district court thinks that even if you did have standing, you just wouldn't have a claim on the merits because you don't have a property interest in the statute. So what about that? So maybe there's some aesthetic injury that confers standing, but why isn't it the case that, the statue belongs to the city of New Haven and they manage city property, and so you just don't have a property interest where, you could say that your constitutional rights were violated through the city's management of its own property?
Paradoxically, that's where, which was much to my surprise, the Connecticut Environmental Protection Act saves us. Because in that instance, lower court holdings have held that asserting an interest in an historic property, which this is, gives a party standing. And what New Haven did in this instance was ignored that standing. And the reason we sued Elliker is he lied to everybody. He said there was a vote.
But you're saying it gives a party standing, under the Connecticut Environmental Protection Act, but your claim, this is a 1983 claim, right? So your claim is that there's a property interest under the due process clause that was violated.
There is an interest that was violated because it was abridged without any notice or opportunity to be heard. The hallmarks of due process.
I get that you have these allegations of the violation of the municipal procedures, but you have to also show that there is a liberty or property interest protected by the Constitution.
Well, we think that's adequately pled, and we think there is. If you don't have a value in your home and its surroundings, what do you have a value in? It's a person's principal investment.
And so, the complaint's pretty conclusory as to the effect on the plaintiff's home. I mean,
It is.
It says, I think, had an effect on the home value, suffered damage to his property interest.
It is, and we didn't think that we had to fact plead. We thought the notice pleading was appropriate. I think at pages 17, 18 thereabouts in our brief, we talked about things that we could have done with an amendment.
I mean, I'm talking about why it's a violation of your property rights to remove a statue that belongs to the city, and you're now talking about property values.
Because it's not a...
Municipal governments do all sorts of things that are stupid and affect property values, but you don't get damages when a municipal government makes a city less livable than it was before, right?
No, but when it loots an historic district, the manner in which it did here, and you're in that neighborhood and you've chosen to live in that neighborhood and acquire property because of the neighborhood's character, as Italian, is literally...
What you're describing now is a standing argument, I think.
Correct.
You're explaining why you're injured. But I'm asking about why there's a violation of property rights protected by the Due Process Clause.
Because a home's value isn't taken in isolation. It's more than the bricks and mortar and land on which it sets. It's the environment and the setting.
So whenever a municipal government makes a public policy decision that reduces the property value of a resident's home, there's a violation of, and it does so in violation of some kind of municipal rule, you can get damages in 1983 from the municipal government.
I don't think I need to defend that proposition to win this appeal. I think we've got the historic district and its responsibility for managing this and the commitment expressed to property owners in the neighborhood that this district would be treated a certain way, and the city ignored it. So this isn't a question of altering the time.
Like a contract, you're saying? Like you have a contract with the city of New Haven to manage the neighborhood in a certain way?
Well, that's a bad metaphor to use in discussing government. Do we have a contract with it at all? But, you know, it strikes me that when the city makes a commitment and people act in reliance on that, it's a contract substitute. Did these people rely to their detriment on a commitment the city apparently made only to change it when political winds changed? That's the contention here. And so we think there is a property interest there.
You've reserved 3 minutes. We'll hear from your adversary.
May it please the Court. I'm Earl Giovanniello. I represent the defendant appellees, City of New Haven and Mayor Justin Elliker. The district court properly held that plaintiff did not have standing. There was no direct injury to the Italian American Defense League. In fact, I think it's shown in the district court's decision that the group was not even formed until after the statute had been removed. And there's nothing that removal of the statute affected had any impact on its core activities. So they're relying on what is referred to as a representational standing. And that comes down to the same injury that Mr. Marcarelli would have had by just having a property that's near the statute.
Well, it's not just having a property, right? So, like, you know, if we take for granted what Mr. Pat has pointed out, that the Supreme Court recognizes these aesthetic injuries, right? So, like, Justice Scalia tells us in Lujan that if I have a plan to go look at wildlife in Egypt and then some kind of government activity interferes with the wildlife in Egypt, I have standing to sue over the government's environmental policies in Egypt. Like, if that's true, how could it possibly be that if in my backyard they change the aesthetics of the neighborhood and I have allegations that I live there because of the character of the neighborhood and it's something I see every day, that's not an injury?
Yeah, the problem is that a universal benefit is not a property interest.
Right, but this isn't a universal benefit, right? Because it would be acknowledged that if somebody who lives in Oklahoma City just reads in the paper that the city of New Haven removed the statue and they're offended by it, they wouldn't get to sue because they don't live there, they don't enjoy the environment, they don't have any plan to go there with which it's interfered. But, like, the allegations here are these are people who bought property in this particular neighborhood because of the character of the neighborhood, and when the character of the neighborhood changes, they suffer an aesthetic injury. That's not a general injury. That depends on the particular people and the reasons for living in that neighborhood, right?
No,
it's just like the distinction between people who are worried about the wildlife in Egypt and the people who have a plan to go visit the wildlife in Egypt, right?
Well, I don't think that's a distinction that would matter. I think the fact
Well,
that
the Supreme Court told us that does matter?
I don't know. I'm not familiar with that case, Your Honor, but I do know that
I mean, this is a standing case. I mean, Lujan is a pretty obvious
yes, Your Honor.
precedent.
But I think the case law is pretty specific that if there's a universal benefit, and in this case they're saying everyone in that neighborhood is affected by it.
But they're not saying everyone in that neighborhood, right? Because not everybody who lives in the city of New Haven is a member of the Italian-American Defense League, right? It is people who live in New Haven because they care about the character of the neighborhood and want to preserve it in a certain way. Obviously, there are people in New Haven who don't have those interests because, you know, at a minimum, the people on the city council who wanted to remove the statue don't care. So that's not universal to everybody in New Haven, right?
No. In fact, the members of the Italian-American Defense League live all over. Most of them are in other places in Connecticut. I think there are only like 5 that are in New Haven.
Okay, fine, but actually, doesn't that show that it's not universal? So let's say we're only talking about the 5 people, right? So there are 5 people in the city of New Haven who say, I moved here because I care about the character of the neighborhood, the quality of it being a Little Italy, and the city's preservation of that environment. And when the city removed the statue of Christopher Columbus, who's a symbol of that neighborhood character, it affected the quality, the character of the neighborhood. I suffered an aesthetic injury, just like people who want to see animals in Egypt. And it's particular to 5 individuals. So how can you say we're talking about a universal benefit if you have to identify 5 specific people in order to explain the injury?
But they're saying it's an aesthetic benefit to everyone who sees this statue in the park, not just
I don't think that's what they're saying, right? Because not everybody moved to New Haven for this reason or cares about that character of the neighborhood, right?
Yeah, I'm not sure anyone did. And that's what makes it so speculative, that the removal of this statue somehow affects the character of the neighborhood so much that they have a right to sue.
Okay, so that's a different issue as to whether anybody actually cares. But let's say, just for purposes of my question, we assume there is somebody who moved to this neighborhood because they like the character of the neighborhood, and they want to live there because they want to live in a Little Italy-type neighborhood.
I understand.
And the removal of Italian hero Christopher Columbus from the park that's across the street from their home alters the character of the neighborhood. Isn't that a harm to that person?
I suppose you could allege that, Your Honor.
So your argument is that that's not alleged in this complaint?
It is not. There is paragraph 11 of the complaint does allege some aspects of that. But to the extent that it is alleged like that, I just don't think it's a liberty interest or a property interest.
Oh, I get that. That's the merits question that I was asking Mr. Pattis about. But so before we get to that, which I'll also ask about, even if you think it's not adequately alleged, and to acknowledge that it's at least possible that such a person would have standing, doesn't it mean that they should at least have the opportunity to provide those allegations to the extent that you think they haven't done it yet?
Yes, Your Honor, but I think that then you have to look at the due process argument.
The merits, you mean?
The merits, which the court did. And I think you can't say that there is a property interest or liberty interest that has been affected by this. Also, I did want to address briefly the argument that there's a Connecticut Environmental Protection Act possibility. That was not presented to the district court. It wasn't even suggested. It wasn't asked. And it's a state law claim. So in order for the district court to retain supplemental jurisdiction, it's within their discretion. I think it's highly unlikely that if there were no federal claim, that the district court would retain jurisdiction.
Well, I think the argument is not that it's that it's a state law claim under the Act. I think Mr. Pattis was suggesting that because the state gives you a right to sue over environmental changes, it means that you have a property interest conferred by the state in the environment, right?
I think you'd have an interest to bring that state law.
I mean, your position would be that just because Connecticut allows you to sue over that doesn't mean you have a property interest in the environment in Connecticut.
Exactly.
Can I ask?
Yes.
Can I ask you some basic questions about
Sure.
moving beyond the injury in fact question? The New Haven residents were not notified at any point that the Board of Park Commissioners would be discussing the possible removal of the statue from Worcester Square Park at the public meeting held on June 17, 20. Is that right?
Well, that's the allegation, but I don't think if we get into the facts that would be the case. The Historic Commission meets regularly, and their agenda is posted on the website, and the public is invited to go to any of its meetings. And it was discussed at the meeting, and there was an approval. So I'm not sure that would matter. But even if that were the case, I think there was a case from this court that indicated that that would not be enough for a due process violation. Let's see if I have that case. I think it's the BAM Historic District case. If you look at that, that doesn't rise to the level of due process.
The homeless shelter.
Yes.
Right, and so there we said that you don't have a property interest in the character of the neighborhood. You might have standing if they alter the character of your neighborhood, but like you don't have a property interest in not having a homeless shelter located near your house because that's a public policy judgment about management of public property.
Yes. And basically, I don't think this is a legal issue. This is a political issue. If there were a different mayor, a different board of alders, a different historic commission, they could just bring the statue back. It's in a museum right now. There's nothing permanent about what's been done. And I'd also like to point out to the court that one of the reasons it was moved was because the city didn't want to pay 24-hour police to guard the statue, which was a point of contention. And in other communities, the statue had been removed, put in the river, graffiti put on it, and it seemed like a sensible thing to do while there was such controversy about it.
It's not disputed that there was no formal vote on the question of whether to remove the statue, right? The statue.
I listened to the tape. They seemed to be asking everyone, and I don't think there was any dissent among the Historic Commission when they discussed the issue. Whether there was a formal vote, I'm not sure, Your Honor.
Were there ever minutes taken reflecting how the board reached this decision?
There are minutes of that meeting, yes.
Where is that to be found? Is it in the record somewhere?
I believe the minutes are posted on the website, and I'm sure they were part of Discovery. I'll have to look. All right. Thank you.
We'll hear rebuttal.
The Lujan hypothetical, listening to it discussed in court makes me wince. I mean, the animals in Egypt, but it's the case. And as is the language in Summers versus Earth Institute.
Sorry, why does it make you wince?
It's hard for me to imagine somebody calling me up and saying I was going to go to Egypt and see the last standing unicorn or whatever, and some public act passed by somebody on a toot in Oregon makes it impossible for me to do that. Would you bring a 1983 claim? I'd have to read Lujan long and hard.
Well, it might be an APA claim or a NEPA challenge or something, but like as you were saying before, it's well established that there is an aesthetic injury, and as long as you have a particularized interest in the aesthetics of the particular place, which might be that you intend to go observe
and I guess
the animals.
What I'm confounded by is how can you have an injury?
So Justice Scalia says the desire to use or observe an animal species, even for purely aesthetic purposes, is undeniably a cognizable interest for purposes of standing.
If it's a cognizable interest, is it a liberty interest or a property interest?
Well, that's a different question. Now that's the merits question.
Well, is it a different question? Is it a different question when the interest you're asserting is your property and the character of the neighborhood and the associational rights that go with it? I think that this case should have advanced to discovery. We could have answered some of Judge Cabranes' questions. I'm not aware that there are minutes. We obviously didn't make these allegations up. I'm not aware that there was an agenda with public notice. What I'm aware of through my clients is Elliker, the mayor, standing up and saying this happened, and people saying what, when, where, and when they looked for answers, not getting any. And so it was as though somebody came into their neighborhood and took up a beloved edifice.
Okay, I mean, I guess your position would be, like, it's a motion to dismiss and you allege that there wasn't notice and a vote. And so, like, we're going to take that for granted.
I think I'm entitled to that at this point.
Right. So, but then what's your response to Mr. Giovanello's argument about the Bann Historic District case where we say you don't have a property interest in not having a homeless shelter in your neighborhood because that's public property and the city gets to decide where it's located.
The difference is
you don't get to decide the character of your neighborhood in that way. The
difference is the assignment to the historic district of maintenance of the park and the statute's role as part of the park. This wasn't a public policy decision to extend. So you're saying that the designation of the park as a historic district confers a property interest protected by the Constitution on the residents of the neighborhood? In part, yes. Because that's why they're... How do you do that? Because you move to a neighborhood because of what it gives you. Not just the home, but the environment that the home is in. And if there are settled expectations, everything about the law is about settled expectations. How do strangers live together without violence? We have settled expectations in the civil and in the criminal. So if I live in a quaint neighborhood for 40 years and then all of a sudden the city puts a homeless shelter in my neighborhood, can I sue for a violation of the Constitution? You're out of luck there unless there's an historic district that cloaked symbols and indicia of that neighborhood as there was in New Haven. That's why there were votes on changing the character of the park. That's what the requirement was. It was a commitment of the city to its residents to behave in a certain way. And when it didn't, the neighborhood changed. And there was no opportunity to be heard. And the neighborhood is their home. Thank you.
Thank you both, and we will take the matter under advisement.